Alright, 62.710, used oil management chapter definitions. In addition to applicable definitions of the 62.701, 200, Florida Administrative definition of the used oil is section 403.75.7 of the Florida State statute following the word phrase of the terms used in this rule. Unless context indicates otherwise shall the following mean: oil, wastewater. So the oily waste means the materials mixed with the used with the oils having become separated from them. The used oil, the oily waste always means materials included wastewater, central fuel, so all its filter residues, sludges, bottom sediments, tank bottom subordinates, which have come in contact with you and have been contaminated by oil processing, means the chemical physical operation designed to produce from the oil used to make the used oil amenable from products of the fuels, oil, lubricants, other used oil derived product process includes blending of the use of oil and virgin petroleum products, blessing the used oil to meet the fuel specifications found in Title 40 CFR Part 279 111 and adopted with the subsection 62.710.210 to the Florida Administrative Code, filtration, simple distillation, chemical physical separation, refining. 3. The processor any processing used in oil to determine includes the transfer facility that stores used in oil longer than 35 days at a time. The used in oil fuel marketer who received the used oil from the transporter who has at least 25,000 gallons of the oil storage capacity. Any person who blends the use of oil on specification used oil fuel with the virgin petroleum product for the purpose of producing on specific used oil fuel. Public used oil collection center, the automotive service facility, government sponsored collection facility which accepts the disposal of small quantities of the used oil from household facilities for the stores of used oil with acceptance of small quantities used for oils from households. Used oil transporter means with the person with the transport uses over the public highways. Any person who collects the used oil from more than one generated transports the collected oil over the public highways. Owners and operators use for the oil transfer facilities. Used oil filter means any device which is an integral part of the oil flow system, the primary purpose of which is to remove the contamination from the flowing oil contained within the system, which is the result of the use of the becoming contaminated, unsuitable for the original purpose, is removed from the surface contaminated and trapped in the used oil. The 7. The used oil filter process means a person who removes oil from oil filters to prepare for recycling generators from the oil circuit. Filters will consolidate the drain and crush their used oil filters from the off-site. Recycling are not used in oil filter processing, provided the generator complies with requirements of subsection 62.710.852 Florida Administrative Codes. 8. Used oil filter transportation means any person who transports over the public highways for the higher use oil filters. Used oil is filed with a transfer processing facility. 9. Used oil filter transfer facility means any facility which is used to store more than 10 days of used oil filter which were not generated facility. A person who stores the own and used oil filters generated on contingency operations of its own property but not considered with the use of a filter transfer facility provided with the used oil filters process the registered oil filter processor. Used oil fuel markets means any person who conducts each of the following activities: direct shipments of off specification used oil for the facility to use the oil burner, or the first claims used oil that has been burned. Energy recovery means the used oil fill specifications set forth in Title 40 CFR Part 279.11 is adopted in subsection 62.710.210.2 Florida Administrative Codes. 11. Used oil transfer facility means the transportation related facility including loading docks, parking areas, and other areas where shipments of the used oil are held for more than 24 hours during the normal course of the transportation over the public highways. Transfer facilities are there stored used oil for more than 35 days. Our processors are defined in subsection 62.710.201.3 Florida Administrative Codes are subject to regulations subpart F of Title 40 CFR Part 279 adopted in subsection 62.710.210.2 Florida Administrative Codes. Rulemaking 403.0601, 403.704 Florida laws implemented 403.703, 403.75, 403.760, 403.767, 403.769 Florida State history. The June 9th, 2005 amended to April 23rd, 2013. All right. Moving on. Alright, 62.710.210 documents incorporated the reference general provision relating to solid waste management may be found in Chapter 62.701 solid waste management facilities for Florida Administrative Codes, with including the statement of intent and the definition, prohibition, general requirements, alternating procedure for the forms, except for the contents indicated otherwise. General provisions apply to this chapter. The Department adopted the reference to Title 40 CFR Part 279 revised in July 1st, 2012. FloridaRules.org gateway reference ASAP number. The reference to 201021888 containing federal standards of management used for the intent obtained with the department and interpreted the standards in a manner consistent with the interpretation obligated by the United States Environmental Protection Agency, except for the interpretation conflict with the Florida law on specifications used of the oil, means of the use of oil which meets the requirements of Title 40 CFR Part 279.11 adopted in subsection 62.710.210.2. Used oil filter containing the PCBs at the concentration equal greater than 2 ppm or less than 500 ppm or 50 ppm is regulated in Title 40 CFR Part 761.2020E. The burned on oil in boilers, industrial furnaces is defined in Title 40 CFR Part 260.10. Adopted in subsection 62.730.02. 01 and identified in Title 40 CFR Part 279.61, adopted in Section 62.710.210.2 Florida Administrative Codes. Use oil contained in the PCBs are concentrated equal greater than 50 ppms of the fully subject to the requirements of the Toxic Substance Control Act found in Title 40 FR Part 761. Blending of the used oil proposed reducing the concentration of the PCBs below the 50 ppms is prohibited in accordance with the provision of Title 42 79 10I 10.1 is adopted by the subsection 62 710 210 2 the Florida Administrative Code Section 61 20E. Reference in Title 2040 CFR Part 279 is adopted in subsection 62, 710, 210, 2. The Florida Administrative Code Title 40 CFR Part 262 in adoption with subsection 62, 730, 168, 1. Florida Administrative Code should mean the rules of the Department regarding the generated hazards with reference in Title 40 Part 263 in adoption subsection 62, 730, 71, 71. With the Florida Administrative Code shall mean the rules adopted by the Department regarding transportation hazards of waste reference to the Title 40 CFR Part 262, 264, adopted in Section 62, 730, 181. Florida Administrative Code 265 has adopted the subsection 62, 730, 182. But the Florida Administrative Code shall mean the rules adopted by the Department regarding the treaters, storers, and dispersers of the hazardous waste reference to Title 40 CFR Part 266 adopted Section 62, 730, 181. Florida Administrative Code shall mean the rules adopted by the Department regarding standards of the management specific hazards with reference to Section 3010 RCR RA shall be meaning notifications of Florida law. The above mentioned department rule of the found in Chapter 62, 730 hazards of waste Florida Administrative Codes. When the same word or phrase, the term defined in 62, 710, 201 Florida Administrative Codes in Title 4 CFR Part 279 is adopted in subsection 62, 710, 210, 2 the Florida Administrative Codes. Definitions not identical. Definitions are given in the Rule 6210. 62, 710, 201 Florida Administration shall apply unless specifically indicated otherwise when used in such provisions adopted in Title 40 CFR Part 279 adopted in subsection 62, 710, 210 2. The United States shall mean the State of Florida Environmental Protection Agency shall meet the Department Administrative Regional Administrator shall make the Secretary of the Department designing appropriate within any reference to Title 40 Part 124 270 and adopted the reference to 40 CFR Part 279 adopted subsection 62 710 210 2. Florida Administrative Code shall meet the provision of Chapter 62 4 62 730 Florida Administrative Code Section 403 722 Florida State Statutes reference to Resource Conservation Recovery Act of 1976 adopted the reference to Title 40 CFR Part 279 adopted subsection 62 710 210 2. Florida Administrative Code is construed to refer the comparable provision of Florida Resource Recovery Management established in Part 4 of the Chapter 403 Florida State Statute Rulemaking 403 061 403 704 403 7545 403 8055 Law Implemented 4074 403 7545 Hit Florida State History News June 8th 1995, amended December 23rd, 1996, March 25th, 1997, June 9th, 2005, January 4th, 2009, April 23rd, 2013. What are we on? We should be on 300 if I'm right. Alright, 300. Alright, 62, 710, 300. Applicability. Used oil management. Rulemaking 403-061, 403-704, 403-767, implemented 40 law implemented 4073, 403-754, 403-754, 403-760, 403-767, 403-769, Florida State History News, June 9th, 2005, repealed February 16th, 2012, and we should move on to the 401. '60U 710-401, prohibitions of the use of oil management. No person may collect or transport, store, recycle, use, or dispose of the used oil, use oil filters, or oil waste except as authorized in Chapter 403 Florida State Statute. No person discharge uses the oil into soil, sewers, drain systems, septic tanks, surface of groundwaters, water courses, marine waters, except provided by here. No person may mix, commingle used oil with solid waste that is disposed of in landfills or directly dispose of the used oil in landfills. Oil waste, subordinates, and other materials for the maintenance to clean up the contained spill and release the use of oil, soil contamination with the use of this result is spilled release are not subject to the prohibition. Some case the Department of Rules, local ordinance, landfills may prohibit the disposal of such materials. Any person who wishes to dispose of solid waste with the use of the landfill which is otherwise prohibited by the subsection must apply with the Department approval of the alternating procedure in accordance with the Rule 62, 701, and the Florida Administration Code. If they base the request and impractical, separate the use of oil, including the oil filters which have not been properly segregated from the old solid waste and by the generator is not guilty of violation under the subsection. The provision is applicable landfill operators who unknowingly accept such waste for the disposal. Notwithstanding the provision of Title 40 CFR 279-10B3, no person may mix or commingle the used oil with the hazardous substances to make unsuitable for recycling or beneficial use. Use of oil shall not be used for road pavement, oiling, for the dust control, weed abatement, or other similar uses that have the potential to release for the used oil in the environment. No person may store or use oil tanks and containers unless clearly labeled with the words used oil in the good condition. No severe rusting apparent with structural defects and deterioration, not leaking, visible leaks. If tanks and containers are not stored inside structures, the contents shall be closed and converted over the wires, protected from the weather. The tanks and container are not double-walled. They should be stored with the oil impermeable surfaces, such as sealed concrete. Asphalt must have secondary containment that has the capacity of 110% of the volume of the largest tank container for the containment area. For the underground storage tank, the capacity is greater than 110 gallons. Above ground storage tanks with the capacity greater than 550 gallons, the facility shall comply with Chapter 62, 761, and 762 Florida Administrative Codes. Rulemaking Authority 403-061, 403-704 Florida State Law implemented 403-751 Florida History, June 9th, 2005, amended to April 23rd, 2013. Alright, now we go on to 500. Alright, also with the used oil management registration notification, the following person shall annually register the used oil handed active with the Department of Youth with the Form 62703, 730-901B with the 8712, the Florida Notification Regulated Waste Activity effective date April 23rd, 2013, here adopted, incorporated the reference www.floridarules.gov with the reference ASB number, question mark number, the equal reference is 02074. The form obtained with the internet with the Department of State, Florida, USA, Waste Quick Topics Forms pages, the 62730 HTM, and contact the heads of Waste Regulation Section MS 450, MS 4560, the Division of Waste Management Department, Environmental, 2600 Blair Stone Road, Tallahassee, Florida, 32399, 2400. Use oil transfer except for the operation listed in Title 40 CFR 27940A1 through 4 that's adopted in subsection 62710-210-2 Florida Administrative Code of Transfer Facility. Used oil process except for the provided under Section 403-754-3 for statute, certain on-site burners where such burning is done in compliance with the air permit, the issue of the Department of Used Oil Fuel Markets will also use oil fuel oil burners office specification used oil. 2. The registration form shall be accompanied with the registration fee of the 100% of the $100 per facility. Is not necessarily sent more than one form of the fee of the registration from the activity. The registration is for an entire transportation fleet operating out of one of the facility sites. The registration form the fee shall be due to the March 1st of each of the year. The registration fee is waived for the use of oil processing facilities for which the permit fee was ruled. 62, 710, 800 Florida Administrative Codes. 3. Upon the receipt of the complete with the accurate with the 6730-901B, the adopted the Florida The reference to section 62.710.501 of the Florida Administration Code of Registration to read the department shall issue the registered person a validated registration from which he shall validate until the June 30th of the following year for the use of oil transportation. Acknowledgement of the registration should include the certification process 62.710.60 Florida Administration Code. The registration is not renewed for the June 30th of the following year because the department has not received the complete and accurate registration renewal documents. The registration fee. The few facilities will no longer be authorized to transport, market used oil or used oil filters, burn off the specification of used oil. Each registered person shall display a validated registration for the identification number of the proponent placement at each facility location. Each public use of the oil collection center shall notify the department no later than 30 days after the first accepting the use of oil from the public on the DEP form 62.710.901.5. Public use oil collection center notification annual report effective April 23rd, 2013, which hereby adopted and incorporated the reference to Florida Rules Gateway with reference number 02071. The form can be obtained with the internet and http www.department.state.florida.us/wake/quick/topics/forms/page 62-710 HTML by contacting the Hazardous Waste Regulation, the MS 4560, the Division Waste Management, the Department of Environmental Protection, 2600 Blairstone Road, Tallahassee, Florida 32399 2400. The department shall acknowledge the filling of the notification within 30 days of the receipt. Rulemaking authority is 403061, 403704. Florida law is implemented 403704, 403754, 403760. Florida State History, February 25th, 1985, formerly 1776.63, 17763, and amended in January 17th, 1990, formerly 1771050, amended in February. June 8th, 1995, December 23rd, 1996, March 25th, 1997, June 5th, 2005, January 4th, 2009, April 23rd, 2013. Alright, 510. Do we have 510 up here? (62.710) used oil management, record keeping, and reporting. 510. Each registered person shall be maintaining the DEP form 62.710.901.2, the used oil and used oil filter record keeping the forms of instruction effective date April 23rd, 2013, which hereby adopted and incorporated the reference of for the www.rulesfororg gate with reference ASP with question number. The reference is 02069. Substantially equivalent forms will contain less the same information as the department form. This form could be also obtained on the internet at www.departmentstate.florida.us waste/kick/under topic of the forms page 62.710 HTML. Contacting Hazardous Waste Regulation section MS 4560 of the Division Waste Management, Department of Environmental Protection, 2600 Blairstone Road, Tallahassee, Florida 32399 2400. These records include the following information: the name of the business, address, telephone number, the EPA identification number of the transfer. The source of used oil included the name of the street address, each of the source and the Environmental Protection Agency identification number, the source and the generation of the one, the total number of the gallons used and received from each of the sources, including the oil waste from which made an integral part of the used oil shipment, the type of the used received. Oil received, the using the type of the code designation found with the form instruction, the date of the receipt, the designation end of the use of the oil and the oil waste included the name of the street address for each of the designation end use for the Environmental Protection Agency identification number, if applicable, then use the code designation for the form instruction, and the documentation of the halogen screening of the accordance with the requirement Title 40 CFR Part 279 adopted in subsection 62.710.210. 2 Florida Administration Codes. Transporters shall maintain documentation of all shipment of the used and included for the accepted transportation as well as the refuse due to the suspected mixing of the hazardous waste. A copy of this record shall be left with the generator. The generator used for the oil transported is only used for oil generated without on contingency operation for its own central collection facility stores prior to having its oil picked up with the centralified use transported, not specifically the subject of the record keeping the requirements of the section. The records required of the section is retained for the period of 3 years. The record shall be kept in street address with the record. Registered persons be available to the inspection department during the normal business hours unless another location inspection is specified with the registration package submitted with the department. 5. No later than March 1st, each of the year, each of the persons registered in accordance with the Rule 62, 710, 500 shall be submitted to annual report preceding the calendar year to the Department of the Form 62, 710, 901, the annual report used for the oil and used oil filter handlers effective to April 23rd, 2013, hereby adopted and incorporated the reference to the Florida Rules or Gateway reference ASPA number the reference 02070. The form can be obtained with the Internet, Department of State, Florida, U.S. Ways Quick Topics Forms, page 62, 710, contacting the Hazard Waste Regulation section of MS 4560 Division Waste Management Department of Environmental Protection, 26 Blairstone, Tallahassee Road, Tallahassee, Florida 32399, 2400. The report shall summarize the record of pursuant to this section. No later than July 1st each of the year, the public is used. The oil collection center shall submit to the department of an estimate of the quantity of the used oil accepted from the public during the previous calendar year. The department shall advise each of the public use of the oil collection center of the requirement of the June 1st of each of the calendar. Rulemaking 403061, 403704. Florida law has been implemented 403754, 403760. Florida State History in the News, February 25th, 1985, formerly 1776.64, 177640, amended January 17th, 1990. Formerly 17710, 510, amended June 8th, 1995, December 23rd, 1996, March 25th, 1997, June 9th, 2005, and April 23rd, 2013. All right, 600. All right, 62710, used oil management, 600 certification program for used oil transport. And used oil transport for the transportation over public highways more than 500 gallons used annually, but not including oil that waste should be certified pursuant to this section. Section should not apply. Any local government provided with the solid waste of the hauler under the contract of the local government to transport used oil collected from the household to public used oil collection center. Any used oil transport is used in oil which has generated its own non-contingency facilities to its own central collection facility, storage, processing, and recovery. However, used oil transport should provide for the proof of the financial responsibility required for the paragraph 2E for the section. As the used oil transporter always transportate less than 55 gallons of used oil at any of the time, the store tightly closed the containers which secured totally enclosed with the secure section of the transport vehicles for the purpose of certification. Totally includes means covered but otherwise protected from the weather. To become certified, maintain certification, used oil transportation shall register annually with the department and comply with the annual reporting required requirements pursuant to section Rule 62, 710, 500, 62, 710, 510. Should evidence familiarity applicable state laws and rules governing oil transportation, submitting the certification that the used oil transportation is familiar with the applicable federal laws of the rules governing used oil transportation, has annually new employees training program in placing of the covering of the applicable rules, maintaining a record of company operating individual personal files indicating the type of the training of the recovery received along with the dated signature with the receiver provided with the training. These records should be retained for the minimum of 3 years, available to review the department personnel during inspection. So then the department annual certification in conjunction with the annual registration requirement of Rule 62, 710, 500, which states the used transportation familiar with the applicable Florida and federal laws, rules governing the used oil transportation, has annual new employees training the program and placing the cover of the applicable rules that is still operating is being adhered to and annually reviewed, updated with the address change of regulation which apply to the operation, which provides explanation for the modification of the training program. However, have been verified the maintained vehicle insurance that combined with a single limit of not less than $1 million such insurance with additional policy must not in no way excludes the pollution and coverage should the sudden and accidental alleged threat and discharge of dispersal, seepage, mitigation, release of the escape of the used oil must include any of the cost expansions in relation to the pollution damage for which the transportation is illegal or liable. Such insurance must be maintained at all times, but exclusively with legal defense costs. The insurance required for the paragraph may be established the evidence liability insurance, either the claim made by the occurrence basis with and without deductible, with the deductible, if any, to be on the occurrence of the pure accident basis not to exceed 10% of the quality equity of the business using the DEP Form 62, 730, 905A with the state of Florida certificate of liability insurance hazardous waste transportation used oil handler effective date April 23rd, 2013, which is hereby adopted and incorporated in reference to Florida Rules Gateway GAF reference to aspiration number the reference 202081. This form can be adopted on the internet. The Department of State, Florida, U.S. Waste Quick Topics Forms, page 62 730, or by contacting the Hazard with Regulation Section MS 4560 of the Division Waste Management, the Department of Environmental, 2600 Blairstone Road, Tallahassee, Florida 32399, 2400. The Blair for insurance policy insured issued by the agent company is an authorized license and transact the business for the state of Florida. The facility has an update to the Department of DEP with the Form 62 730 905A with on the file of the Department at court with the form accepted the renewal same policy with the same character information with the court from the brand matches of the DEP with the 62 730 900A 5A with the Department on the has in the file facility including the policy number. The Department has received documentation form. The insurance certifying liability policy has not changed along with the Accord form. For the business entity, the registration in Florida, evidence for the self-insurance provided with the Chief Financial Officer of business entity. 2. The states and federal government accept with the requirements of the paragraph. The Department shall issue certification each of transportation provided with reasonable assurance of the compliance with the requirements of this section, which shall be valid with the current registration period of activation provision section 4030877 for state law applied to the certified with the use of oil transportation state statutes. Revocations are according to the procedural requirements section 12 12060 Florida State statutes upon finding the department that should transportate has submitted a false inaccurate information application has violated statutes the department authorized to enforce the department orders rules or certification conditions has failed to submit the reports of other information required of the department rule permit conditions refused to allow the inspection of the records and equipment in the department of personnel other personnel which such inspections authorized department rule permit condition Florida Rule 403061 403704 403767 Florida State Laws 403767 Florida History News January 17, 1990 formerly 1770 17 710 600 amended in June 8th 1995 December 23rd 1996 March 25th 1997 June 9th 2005 April 23rd 2013. Alright, now on to 800. Alright, we're still in the chapter 62, 710, used oil management. This part is 800 for permits for use for the oil processing facility. The rules shall apply to any of the owner-operator of the facility that is processed with the use of oil. The owner-operator should comply with the requirements of the chapter, including the requirements of Title 40 CFR Part 279, Part F. Processing does not include the removal of the used oil with the wastewater solely for the processing, making the wastewater or stopping form water acceptable to meet the discharge limits within other permits. However, the used oil generated for such activity is subject to this chapter. The sedimented material removed from the oil water separated with the disposal and subject to requirements in Chapter 62, 730 of the Florida Administrative Codes. Permits shall not be required under this section for generators aggregated with the use of the oil with the virgin oil with the unspecific use for the oil for the purpose of burning on specification of the oil with the aggregation site provided with a valid air permit. The authorization of such burning in effect with the facility permit should not be required under the section. The facilities conduct processing operation incidental burning with the fused oil fuel on site provided with a valid air permit authorizing burning in effect. For the facility, all used from the oil field is the burned on site, and the owner of the operator of the used oil processing facility shall operate, modify, and close the facility only pursuant to the permit issued by the department in accordance with this chapter. Before operating, closing, and making any substantial modification to used oil processing facility, the owner and operator shall submit the Department of the Used Oil Processing Facility Permanent Application Depth Form 62 710 9016 Used Oil Processing Facility Permanent Application effective date April 23rd 2013 where hereby adopted and incorporated the references for Florida Rules or Gateway reference as question number of the reference is 02072. The form can be obtained with the internet with the Florida Department of State, Florida U.S. Waste Quick Topics Forms, page 62 710 by contacting the Hazardous Waste Regulation Section MS 4560 of the Division Waste Management, the Department of Environmental Protection, 2600 Blairstone Road, Tallahassee, Florida 32399 2400. Engineering aspects of the application should be certified by the professional engineer pursuant to the subsection 624050 and 7 of the Florida Administrative Code. Substantial modification means the modification reasonable with expected to lead to substantial different environmental impacts which require a detailed review of the purpose of this section is an increase in the storage capacity of the facility of 25% or 25,000 gallons, whichever is less considerable the substantial the modification pursuant to paragraph 62 4.050 4S, Florida Administrative Code, minor modification means the modification that does not require substantial technical evaluation of the environment, does not require news and site inspection. The determinant will not lead to substantial different environmental impacts, will lessen the impact of the original permit for the purpose of the subsection replacement of the existing tanks with the new tanks and considered minor modification. Change of the facility will involve the routine maintenance such as repair equipment, the replacement of the equipment with similar equipment. The aesthetic changes, the minor operational changes that are not considered modifications do not have to be reported to the department. It requires no permit-free facility operators advised to contact the department if they have questions on whether the change would be considered routine maintenance. Notwithstanding the provision of Rule 62.4.050, Florida Administration Code, the fees are used. The oil process permit application included with the permit renewal application is $2,000. The fee of substantial modification to the permit is $500. No permanent fees is required for the minor modification. The application renewal permit should be submitted to the department at least 60 days prior to the expiration date of the existing permit in accordance with Rule 62.4.090 Florida Administration Code. All right, 5A, the owner or operator of the used oil processing facility should be submit the department as part of the permit of the application written closure plan to show the facility will close to meet the following requirements. There will be no further need for further facility maintenance for the used oil. Used oil will not contain surface or groundwater. All tanks of piping, the secondary containment, the ancillary equipment will be equipped and cleaned and decontaminated with all materials removed and managed. The closure plan shall be updated whenever the significant operational change occurs. The discharges that are made. The closure shall be maintained with the records under the Rule 62.710.510 for the Florida Administrative Code. The owner and operator shall notify the department of writing within 60 days prior to the scheduled date of the closing facility. Within 30 days after the closing of the facility, the owner and operator submit the certification closure completion to the department that demonstrates the facility closed with a substantial compliance. The detailed closure plan, in addition to the professional certification required with the rules promulgated pursuant to the Section 376.30701 per certification to be signed by the owner and the operator of the facility. Within 30 days of determining the facility was closed in accordance with the closure plan, the department shall release the facility with the financial assurance obligation for financial assurance. The owner and operator of the used oil processing facility should provide the department with the proof of the financial assurance issued with the pay for the state of Florida and the amount of the closing cost estimate for the facility. The proof along with the closing cost estimate should be submitted to the department as the part of the permit application process of the facility. Providing proof of the financial assurance should consist of either the surety of the bonding of the guarantee with the payment of the surety bond of guaranteeing performance, which complies with the requirements of Rule 62.701.630 Florida Administrative Codes. An owner and operator may request an alternative proof of financial assurance in lieu of or in a combination with the requirements of surety bond consisting of one or more of the following financial instruments in which comply with the requirements of Rule 62.701.630 of the Florida Administrative Code. Trust fund, irrevocable letter of the credit, insurance, and financial testing, and the corporate guarantee financial documentation submitted by the Form 62.701.905 A, B, C, D, E, F, G, H as appropriate. For the purpose of determination of closing cost estimates, the owner or operator shall estimate the total cost of the closing facility Form 62.710.901 for used oil processing facility closing cost estimate form effective date for April 23, 2013, which here is adapted in accordance with the reference of Florida Rules Gateway, the reference number, the reference 02073. This form can be obtained with the Internet, Department of the State, Florida, USA, Waste, Quick Topics Forms, page 62, 710, containing the hazardous waste regulation, MS 4560, the Division Waste Management Department, Environmental Protection, 2600 Blairstone Road, Tallahassee, Florida 32399, 2400, in accordance with the closure of the plan, pursuant to subsection 5 of the section for the owner of the type of the facility, owner, operation, with the extent of the manner of the operation, making the closing more expensive. The owner or the operator should submit the estimate together with the necessary justification to the department along with the proof of the financial assurance. The cost is estimated with the certified professional engineer for the third party to perform the work on a per unit basis with sources estimated to indicate the owner or operation will keep the latest costing estimate of the facility. When the estimate has been adjusted in accordance with the paragraph C of the subsection, the latest adjusted closing cost estimate shall also be kept at the facility. The owner or operator shall annually adjust the closing cost estimate inflation change of the closure plan. The shall is submitted to update information to the department between January 1st and March 1st for each of the year. Such adjustments may be made either by recalculating the maximum cost of the closing the current dollars using inflation flags derived from the most recent implicit price deflated for the gross national product published by the U.S. Department of Commerce Services. The current business inflation factor is a result of dividing the last published annual deflator by the deflator for the previous years. The value of the funding mechanism is the total amount of the current closing costs, and the owner and the operator shall provide the funding mechanism to reflect the new estimate. Rulemaking Authority 403061, 403704, Florida Law Implemented 403704, 403707, 403769, Florida History News, January 17th, 1990, Form 17 800, amended June 8th. 1995, December 23rd, 1996, June 9th, 2005, April 23rd, 2013. And that was 800. Now we move on to 850, and then 901. All right. 62710, we're still in used oil management. 850, management of used oil filters. Prohibition. No person removed or managed the used oil filters shall dispose of such filters commingling filters with oil solid waste at the disposal landfill in Florida. If it is responsible for the generator to make reasonable efforts to ensure that such filters are not disposable of in the landfill. This prohibition shall not apply with the used oil filters generated in the individual household. Generators, each generator of the used filter which solid waste typical disposed of the oil in the landfill such as either register as the used oil filter processor shall ensure the filter is transported to the registered oil filter transportation process by the registered oil filter process at the end of the use that does not include the person who recycled the engine block, one of which the used oil filters remain. The generator of the used oil filters exempt of the registration and reporting requirements of the rule, provided that their transportation other than used oil filters and sealed with a container of 55 gallons or less was secured with the vehicle owner by the generator. Registration of the following person shall register the department in accordance with the requirements of subsection 62710 and 4 of the Florida Administration Code. The used oil filter transporters, the used oil filter transfer facilities, used oil filter processors, and end user of the oil filters, including scrap metal dealers, metal foundries, waste to energy facility, thermal and processing units such as cement kilns, who accept the oil filters of the person who is not registered with the oil filter process. End users should not be required to comply with the provision of this section with respect to the used oil filters that have been obtained or from a registered used oil filter processor. The used oil filter processor, each registered oil used filter processor shall maintain records of Form 62.710.9012. It's adopted in reference in subsection 62.710.510.1 for the Florida Administration Code. The substantial equivalent form that contains at least the same information as the department form. This record should include the destination and end of the use of the process used oil filters, including the name and street address of each of the designation of the end of the user. The records required for the subsection shall be retained for the period of 3 years. The record shall be kept at the street of the registered person shall be available to the inspection of the department during the normal business hours. C. No later than March 1st, each of the rear of the registered oil filter processor should be submitted with the annual report for the proceeding with the calendar year of the department on the Form 62.710.9013 of the adopted reference subsection 62.710.510 of the Florida Administration Code. This report summarizes the records kept in pursuant to the paragraph A of the subsection. 5. General rule requirements for the storage of used oil filters. All persons storing the used oil filters should store used oil filters above the ground containers which are clearly labeled. Or used oil filters which are in good condition, no severe rusting apparent with structural defects and deterioration, with no visible oil leakage. The container shall be sealed or otherwise protected with the weather and stored within an oil impermeable surface. Upon detection of the released oil filters for any of the used oil filter container with the facility owner of the operator shall stop the release, contain the released oil, clean up the managed properly with the release of oil with any of the subsequent oil waste in accordance with the provision of Chapter 770 Florida Administrative Codes. If applicable, repair and replace any leakage oil filter storage containers prior to the return of them to service. Rulemaking authority is 403061, 403704, the Florida State Law Implemented 403751, 403754, 403769, Florida State History News, June 8th, 1995, amended April 12th, December 23rd, 1996, June 9th, 2005, and January 4th, 2009, April 23rd, 2013. And then the remaining one should be 62.710.901. Alright, the used oil management 62.710 and the 901 forms. The forms listed in the rule number, which is also with the form number with the subject title and effective date. The forms can be obtained with the internet, http://www.department.state.florida.us/ways/quick_topic. The forms page 62.710 HTML. or containing the Hazardous Waste Regulation Section MS 4560 of the Division of Waste Management, Department of Environmental Protection, 2600 Blair Street, Stone Road, Tallahassee, Florida 32399, 2400 reserved. Number 1 is reserved. U2 is used oil filter record. Keep the form and instruction effective April 23rd, 2012. It's adopted and incorporated the reference to subsection 62, 710, 1 of the Florida Administration Code. The annual report by used oil and oil filter handlers effective April 23rd, 2012. Adopted and incorporated the reference to subsection 62, 710, Florida Administration Curve 4 Reserve Public Use 5 Public Use Oil Collection Center Notification Annual Report effective April 23rd, 2012, which is adopted and incorporated by the reference to subsection 62, 710, 505 Florida Administration Codes. 6. Use oil processing facility permanent effective application effective April 23rd, 2012. Adopted and incorporated the reference to subsection 62, 710, 803 for the Florida Administration Codes. And the used oil processing facility closed cost estimate effective April 23rd, 2012. Adopted and incorporated by reference paragraph 62, 710, 806B of the Florida Administration Codes. Rules Authority 120.53.1, 403.061, Florida laws implemented 403.754, 403.769, Florida State History, December 23rd, 1996, amended June 9th, 2005, and January 4th, 2009, April 23rd, 2013. And that concludes the used oil management 62.710 text session, or the subsections of the used oil management chapter.